Hey, I'm Henry Quillian. I'm here at Taylor English Duma with my colleagues of the litigation group. And this is the first Quillian's Kernels of 2024. And it also, strangely, is the first Quillian's Kernels of all time, a repeat from maybe 12, 14 years ago, where we started in the Civil Practice Act and worked our way through it and learned all the practical things you need to know to survive in a lawsuit, avoid do-overs, and to avoid malpractice while also being very effective and efficient for your clients. At Taylor English Duma, we are doing this as a training tool within our group and also for the general knowledge of people out in the public when this is presented. So we do try to avoid calling judges by name in comments and such as that, because we would like to be able to put these videos online. But on the flip side, we're very interested in interactive conduct and discussion about what's happened in various circumstances as we discuss them along the way. However, we are not providing legal advice to anybody out there in the world. And so if you want to bring a lawsuit, either get a lawyer of your own or study it on your own, but only use this as general informational background. I'm going to be referencing a lot of books and statutes and things like that you can read and learn for yourself. And so this will hopefully help you get to the right place to find the current and right answer. Just in general for this session, and probably for the foreseeable ones, we're going to be working in connection with Georgia courts that are called courts of record, which are basically the superior and state courts in the counties around Georgia, which are controlled by the Georgia Civil Practice Act found in OCGA 911, 1 at SEC, and also the Uniform Superior Court rules of the state of Georgia, which look like they're a lot of rules. And in connection with that, the Civil Practice Act are statutes got passed by the legislature. So sometimes they get behind the times, for lack of a better description, and have to be updated subsequently. And then also they're passed by the legislature. So sometimes they are messed up, for lack of a better description, because some legislator doesn't really understand how the words they want to put into a statute affect real life. In addition, the Superior Court rules I have found are generally now published on the websites of the superior courts in Georgia. However, they are promulgated by the superior court judges and approved by the Supreme Court. And in recent history, I've found that the Supreme Court website has the actual updated version of the Uniform Superior Court rules, whereas various courts around the state publish them, but they're the old rules. So if we're going to talk about the Uniform Superior Court rules, I think you actually need to go to the Georgia Supreme Court website, look at the rules page, and they actually have the rules there for a whole bunch of different courts, including the Superior Court rules. Just so you know, in the state courts have made modest adjustments to the Superior Court rules. And so for certain things, you need to double check and look at the state court rules. And then also, once a case gets started, you need to look at the standing orders of the court, the specific judge that you have. So what are our topics today? We're starting at ground zero, beginning of time. How do you file a lawsuit? How do you start a lawsuit in Georgia? Can anybody give me an idea of what the purpose of starting a lawsuit or filing a complaint would be in Georgia? Mr. Rezak?
One is to start a case, to initiate a case, and also to start the process for establishing jurisdiction, personal jurisdiction over your defendant.
Okay, excellent. And amazingly, that is what the Civil Practice Act says. Now, these are my excerpts from the Civil Practice Act that I circulated to my colleagues here at Taylor English. This happens to be Official Code of Georgia annotated 911-3, and it says a civil 911-3A says a civil action is commenced by filing a complaint with the court. So how do you start a civil action? You file a complaint. What is a civil action? 911-2. There is one form of action to be known as a civil action. So the goal initially of filing a complaint is starting a civil action. Now, why do we have civil actions? Anybody got a suggestion?
Is it monetary relief instead of criminal?
Monetary relief would be a very important one. Any other kind of relief we might get in a civil action?
Injunctive.
Injunctive relief. And under 911-8E, let's see if we can find that quickly. It says that pleadings are to be construed to do substantial, excuse me, that's 911-8F. All pleadings shall be construed to do substantial justice. So a civil action hopefully will lead to substantial justice. And of course, that could be substantial justice for the plaintiff or substantial justice for the defendant and or counterclaimant. We'll have to see how it all works out down the road. Now, where did all these rules and everything come from? Why do we have tons of rules about how a lawsuit is done in the United States and specifically in Georgia?
Because they're done differently all over the world.
They're done differently all over the world. And what do we have in the United States and in Georgia that the rest of the world doesn't have under our specific formulation of it? We have constitutions, and constitutions require due process, and due process requires notice generally and an opportunity to respond. So a lot of the things we're talking about today about starting a lawsuit are how do you actually functionally get it started? And then separately, why do we do the things we do? Why are the rules the way they are? And I think a lot of times, if you only know what the reason for the rules are, the underlying reasons, you can understand and remember better why you have these rules that make you do X, Y, and Z, and you can't cheat on them because somewhere along the way, somebody's determined that if you don't do this, then the defendant in particular, in this instance, isn't going to have due process. If the defendant doesn't have due process, you don't get substantial justice, and you might violate the Constitution. And nobody wants to violate the Constitution, except for some people I can think of. We have a nice little hypothetical, which lawyers love to use. And we are going to use it to talk about the commencement of a lawsuit in Georgia, what steps you need to take, why you need to take those steps, and what good it does to do the steps in the correct way. And the hypothetical has been distributed to my colleagues, but I will read it because it's very short and it brings up a whole bunch of different points. The case will be entitled Solvent Sally versus Deadbeat Dan. 5 years and 364 days since Deadbeat Dan missed his payment on a note held by Solvent Sally. Sally comes into your office at 3 p.m. and tells you, I want to collect on this note. You are in a small town and your office is situated directly across from the Superior Court. Deadbeat Dan may, however, live just across the county line. But it's Friday and the clerk, has a habit of leaving for Friday night lights. In Georgia, y'all, that's football. What must you do? Wise lawyers might say turn down the representation, but other wise lawyers inform you to ask for a big cash retainer and to go for it. Though you've never filed a complaint before, the light bill is overdue and you've been sitting on your duff all month, writing contracts, long awaiting your chance to be a real lawyer. this is your chance to represent Solvent Sally in court. Unfortunately, however, they do not teach you anything in law school that's practical, like how to start a lawsuit. So now you have maybe an hour to figure it out. You know that this is not a criminal matter, so it must be a civil matter. John Travolta's movie, A Civil Action, comes to mind. So you figure out that is what you need. Because the Superior Court is closest by, you want to file there. It is a court of record under OCGA 911-1. All the answers you need are in the Civil Practice Act and in the Uniform Superior Court rules, but you don't have long. So.
Why not? Why don't you have long? Why
Okay.
can't you wait till Monday?
Well, we're at 5 years and 364 days since Deadbeat Dan reached the note agreement. And what might that be? A problem,
Statute of limitations.
a statute of limitations problem. So one of the very first things we're going to think about when we're bringing a lawsuit is what are the most easy ways that you can get, that a defendant can get a case thrown out that you have filed. What would be one of them that might happen to Solvent Sally?
If the case is not filed within the statute of limitation.
Okay, so that's why we only have 1 hour to figure this out and to get the case filed, because the statute of limitations is like a complete cutoff of your ability to bring a lawsuit on that note, right? What would be another way that you could possibly, that a defendant could easily get a case thrown out?
If the defendant is never personally served.
If the defendant is, yes, if the service of process either is defective because of lack of paperwork, or because you actually never get the service on the defendant. And we'll go, by the way, the general goal for this session is go through what's in a complaint, possibly and hopefully start general service of process rules. What else could be in a contract that would result in your case possibly being thrown out of court or possibly stayed immediately upon the answer of the defendant?
Arbitration.
An arbitration clause. So it would be good for you, the lawyer sitting across the street from the courthouse, otherwise sitting on your duff writing contracts, to see whether the note has an arbitration clause in it. But under the circumstances, might you file a lawsuit anyway? Under the circumstances, I would say in that you can't really start an arbitration on the dime. There's very few mechanisms for getting that accomplished that fast. File a lawsuit and ask for the court to stay the lawsuit pending arbitration. That way you've got a civil action going within the statute of limitations. But we'll talk about how the statute of limitation plays into all the steps you need to take going forward. So we've already talked about the need for civil action. We've talked about the fact that the filing of a complaint commences a civil action. What else has to go with the complaint in order to make it a complete lawsuit that you can serve on the opposing side? Deadbeat Dan.
Summons.
A summons. What is a summons?
Summons issues from either from the clerk of court usually, and directs the defendant to answer within a given amount of time.
Aha, a summons that's exactly right. The summons is a document that is signed by the clerk, but it's effectively an order from the court that has to be provided to the defendant as part of we talked about service of process. It's part of the process, which is in this instance is referring to paperwork, not a process. And it actually says on it, Mr. Defendant, you must file an answer within 30 days of service. Otherwise, you will be in default. So effectively, it's an order of the court saying you must show up, you must do that. Otherwise, there will be dire consequences. Now, what has to be on a summons? Well, we'll walk through that because there are very specific requirements of what has to be on a summons for it to actually be a summons. But we will start with the complaint. So we've talked about this hypothetical, and I mentioned the title would be Solvent Sally versus Deadbeat Dan. In a lawsuit, a complaint must have a style, and that style is directed to be on there pursuant to 911(7), which directs what is a pleading in Georgia, which is essentially a complaint, an answer, a counterclaim, a third-party complaint, and a response to the third-party complaint. And then 911(8), I believe it is, 911(10), OCJ 911(10) talks about the form of pleadings. And we can just walk through this. It says it has to have a caption. What is a caption? A caption has to have the court that you're filing in and the county where the court is. It has to have the names of the parties, generally set up in a vertical fashion on the left side of the complaint, where it says Solvent Sally, plaintiff, Deadbeat Dan, defendant. And it's got to have a title that says this is a complaint. And some courts require you to say a complaint for what? For breach of contract, breach of note. That's always would be amendable, but you might want to go ahead and put in your title what kind of complaint it is so that everybody will know. And then it has to have separate paragraphs laying out what the allegations are against the defendant, and then we'll go into some of the details of how that's set up. But you will note that along with the summons, which we mentioned, and the complaint, you now have to file a general civil and domestic relations case filing form, information form. And this form has very similar information. It says who the plaintiff is, who the defendant is, who the plaintiff's lawyer is, and you have to fill in boxes. It's basically a data collection thing that says what kind of lawsuit it is generally. And it also has a certification when signed by the lawyer that says you've redacted all personal information that would be required under OCGA 911(7.1, which is a privacy statute that's come into effect. What sort of information might you need to take out of a note that has been signed by Deadbeat Dan, if it happens to be on the note, in order to meet the certification under Rule 911(7.1?
Account numbers, social security numbers, sometimes addresses, in other documents, information relating to minors.
That's right. So read the rule. There are a lot of things in that rule that says in this instance you have to take out X, Y, and Z, but you can leave in the last 4 digits of the account number or the social security number. But the general idea is, especially now with electronic filing and electronic access to filings, they want to get all the personal information that might be harmful to the defendant off the public record. It also asks, interesting, will an interpreter be needed for this case? And that could be a foreign language, that could be sign language or something of that nature. And then are there any special disability accommodations that need to be taken into account for this case? All this would be to alert the court and the court's chambers as to things that might be unique for this case. So we have to have a complaint, we have to have a summons, we have to have a civil and domestic relations filing information form. Now, chances are the clerk is going to not let you file it unless you have all those 3 pieces. But it does say in the rule that if you don't happen to file this or file it right, you can fix it later, this particular form. But that is not true of the complaint. You need to get it filed. You need to get it filed right. What does a complaint need to have in it? Does it have to be a long description of everything that happened between the two parties during their relationship?
No.
No. Okay. It is to be a short and plain statement of the cause of action or causes of action, including potentially alternative or contradictory causes of action. And it's supposed to be laid out in a logical fashion where short and plain statements are used regarding the facts in a numbered paragraph so the other side can respond in a numbered paragraph. If you look at OCJ 9-11-10, it says paragraph, separate statements. All averments of a claim or defense shall be made in numbered paragraphs, the contents of each of which shall be limited as far as practicable to a statement of a single set of circumstances. And a paragraph may be referred to by number in all succeeding pleadings. Each claim founded upon a separate transaction or occurrence, or each defense other than denials, shall be stated in a separate count or defense whenever a separation facilitates a clear presentation of the matter set forth. So the idea here would be concise, direct, separated when you're mixing in various concepts associated with the complaint. Now, what might we have in the complaint by Solvent Sally?
So first, she would say who she is and that she's a Georgia resident, most likely. She would say who deadbeat Dan is and his address and where he can be served, and why the court has jurisdiction, why the venue is appropriate. And then she would talk about the transaction, about when the note was signed, probably give a short statement of some of the key provisions, the payment provisions, and then include an allegation that it hasn't been paid and what her damages are.
Very good. All within separate, broken down. Now, why would you want to break down, if you can, why would you want to break down your allegations into separate paragraphs?
Well,
Long term, what's the good of that?
A couple of reasons. One is that the court wants it to, I think the court wants the parties to be able to litigate and plead in an understandable way. But also there are, depending on how deadbeat Dan answers, he might be admitting certain things in your complaint. So if you load too much into a paragraph in your complaint, he could perhaps deny the entire paragraph. That might not be proper for him, but still you're not going to have a simple admission when you otherwise could get it from him.
Right. It's excellent to try to move your case forward by getting as many admissions as possible from the defendant. So you want to think about that when you plead, so that hopefully at least all the building blocks of your case will be admitted. For instance, deadbeat Dan might admit that he signed the note, admit that he made payments, deny that he missed a payment, but at least you've already established that there's a note and that he made payments and that the note applies to him. You might have to fight over whether he missed payments or whether he was late on payments or whatever. But if you put it all into one paragraph, he might just deny the whole thing because he did make payments according to him, and then you would have no admissions and you'd have to prove everything going forward. Now, also, do you have to attach the note to the complaint?
You don't. It may be a good idea, but you don't.
All right, so yes, as long as you state a cause of action, you don't have to attach the document. In fact, I filed one, 200-page insurance policy. I sued for breach of the insurance policy recently. Didn't attach it, didn't need it, didn't have to. It was going to muck things up. So, but however, and this is very important to remember because you might want to take into account under 9-11-10C. It says adoption by reference exhibits. Statements on a pleading may be adopted by reference in a different part of the same pleading. In other words, we hereby incorporate paragraphs 1 through 3 into this count of a complaint. or in another pleading, or in a motion, a copy of any written instrument, which a note would be, which is an exhibit to a pleading, is part thereof for all purposes. So, for instance, if you attach the note becomes part of the complaint, right? So that would be good if you say a true and correct copy of the note executed by deadbeat Dan is attached here to Exhibit A. If he admits that, then you've got a fundamental fact established. He admits he signed the note. And then you might have another paragraph that says this note was given upon good consideration. If he admits to both of those, then you've got an enforceable note. If you had signed a release for deadbeat Dan, but you had never given it to deadbeat Dan, would you want to attach it to your complaint?
No.
No, you wouldn't, because it may become part of your complaint. And under Rule 911-10C, unless you're really, really clear that this was never delivered, it was never paid for, et cetera. I just wrote it and signed it in advance of, because you don't want to confuse the court by having a note saying it's not paid and then having a release saying it was paid or that it was satisfied. So you don't want to put junk on your complaint that might screw up your whole lawsuit, because that just leads to motion practice and a whole bunch of mess. All right. So what else do you have to have on a complaint? After you've done all these things that Mr. Rezac has suggested, venue provisions, which I will, by the way, point out is expressly required by the Civil Practice Act, because Georgia is very strict on venue. And then all the statements regarding your cause of action. What else do you have to have?
Your causes of action, your counts.
Oh, you have to have a prayer for relief, at least. You could either have it in counts, but if you just got a one count, he breached the note and didn't pay, then you nevertheless have to have a prayer for relief. You have to ask the court, tell the court, this is what we want out of this lawsuit, and that is 911-8A-2B, a demand for judgment for relief to which the pleader deems himself entitled. And then there's a whole subsection, by the way, on medical malpractice actions, which we will not discuss. Just be aware that if you're filing a medical malpractice action of any kind, which is fairly broad, basically anytime anybody gets hurt by a care provider, be careful what you plead, because you can be thrown in contempt of court if you claim too much. But so you got the caption, you got the title, you got the paragraph setting forth the venue, facts, who the parties are, why you're suing deadbeat Dan, the instruments you're relying upon, your demand for relief. What else do you need?
Signature?
Oh, a signature. Why do you need a signature? I mean, it's electronic filing. It doesn't make any difference, right? It's just typing on a piece of paper.
Oh, no.
No. Well, take a look at OCGA 91111, because it requires that all pleadings, which we know this is a pleading because of 911-7, must be signed. And if they are signed by an attorney, they must be assigned by an attorney who is authorized to practice law where, if you're filing a lawsuit in the state of Georgia.
Georgia.
In Georgia, yes. And that attorney has to be in what? Blank? Good standing, yes. All right, so you're gonna have an attorney identification block on the bottom, usually at the end of the complaint. And it's gonna have a signature line. What else is it gonna have for that attorney?
Their bar number?
Gonna have the bar number. What's another fundamental thing they're gonna have to go with that bar number? The name of the attorney typed out, the name of the law firm, fax number. I don't know why they still require that, but they do. Phone number, and what else special thing do we have to put on there in the last, say, 10 years or so?
Email address?
An email address. which, by the way, we'll go over it. Putting that email address on there has all sorts of magical consequences under the rules. And so, and most importantly, even if it's electronic filing, you've got to have a signature. So when I was a brand new associate, I'm talking brand new. Senior partner, a big law firm, comes up, puts a complaint this thick in front of me and says, tell me whether it states a cause of action, how we can move to dismiss. And that thing had every statute known to man cited in it. And so I went up to the library for days, looking at statutes, reading the complaint. Finally, I came back down from the library and they said, oh, well, we've already moved to dismiss that complaint. How did they move to dismiss it? Even though it had a million things cited in it, hundreds of pages of gobbledygook, the plaintiff didn't sign the complaint and they won. So I think it was an exercise in just how bad of a lawyer Henry Quillian was, because he had not been to Quillian's kernels at the time. But that is my war story regarding the signing of a complaint. Okay. So always remember to sign. So if you're a paralegal and you're listening to this or here, what should you always check? What is one thing you can definitely do that you should always check before your lawyer who's been working on a draft complaint for weeks and sending around copies of it without a signature? What should you always check to see it that is on the complaint?
Signature.
A signature. And you all better check out that bar number and everything else too, but signature is going to be not good if it doesn't have a signature. And in electronic filing, that's often S/S and then the name of the lawyer filled out in full. Now, we've been talking about electronic filing. You're across the street from the courthouse. You've been sitting on your duff writing contracts since you started practicing law. What better you think about pretty early on in the process of filing this lawsuit against Deadbeat Dan?
Whether your court has electronic filing.
Yes, whether your court has electronic filing, which now every court in Georgia does, court of record, I believe. And you might want to go ahead and call the clerk who you know leaves early to go to the football game to tell them, I've got to get signed up for this. I have no idea how to do it. I want to come over and to your kiosk at near your filing desk, which is basically a computer. And I want you to help me get signed up so I can file this one-page complaint that I have drafted up and get it on file right away. So I don't think it's easy peasy. I think it takes 30 minutes, an hour, whatever, to get signed up for electronic pleadings. And also, to make it even more complicated, in Georgia, the counties aren't consistent on which service they use for electronic pleading. So, and there may be a lot of data you have to put in there regarding your signing on. So one of the earliest things you're going to have to think about is controlling that courthouse and that clerk to try to help you get in the door and get that pleading filed before midnight passes. And so hopefully if you tell your young lawyer, you go and you tell the clerk, I know it's Friday night. I know your child's the quarterback of the football team, but this is my very first lawsuit and the statute of limitations runs today. Please, please, please help me actually get this thing filed electronically so that I can get it on file. So we talked about the summons, which is the other paperwork, and that summons will be in a form issued by the clerk of court. And the clerk of court should have a summons that is hopefully, there's actually been litigation over this in the past, hopefully actually in compliant with the law. And what must the summons have on it? The summons must have basically the names of the parties. Most importantly, the name of the defendant you are suing. And it has to have the what of the clerk.
Signature.
Signature of the clerk, because it is not an issued summons, it's not a summons, it's just a piece of paper. And the form will have the language that says this is what the defendant is supposed to do upon getting the lawsuit. And if it doesn't have it, well, you might ask the clerk, don't you think we better write onto this summons that the defendant has to respond? Because the law actually requires the summons to have certain things in there. Now, what else might the summons need to have on it? It needs to have the identity of the pleading that is being served, which almost always is the complaint. But there is a lawsuit that I attached, a appellate decision that I attached to the circulated materials, Anglin versus State Farm Fire and Casualty Company, where it was ultimately held that the court case was properly thrown out because the summons that was used by the plaintiff did not have the name of the defendant on it. And also it didn't identify whether it was the complaint or the amended complaint that was being served. And the defendant came forward and said, this is a defective summons, therefore it's insufficient process or faulty process, therefore the lawsuit has to be thrown out. And the court held it was a non-amendable defect, and the plaintiff better hope that the statute of limitations hadn't run. Secondly, there's a case on here, which is Bank South versus Stamps, or Stamps, STAMPS versus Bank South, who was a lawyer who had signed a note. He accepted service of the complaint, but they never served him with a summons, and he had his case thrown out because they litigated all the way up to the Court of Appeals. He never got a summons, so the case was defective, so he got the case thrown out. And I don't know whether they ever were able to come back around and sue him again, or whether they just settled or gave up after fighting with. But that's 221 Georgia Appeals 406, 1996. Okay, so we're down at the end of the statute of limitations, right? We're going to get this complaint on file just in time. But what is your concern if you're bringing a lawsuit right at the very end of the statute of limitations? You've got to timely serve the defendant. And given the fact the statute of limitations will have run, unless you find deadbeat Dan at the midnight, before midnight on the day you filed the complaint, have him served, then he will have an argument that I wasn't served on me until after the statute of limitations had run. We do have the statute that says a civil action is commenced upon the filing of complaints, so that's a good thing. But the case law says that you have to be able to show diligence in your efforts to serve the defendant rapidly after the running of the period of limitations. So are you going to be able to do that with the sheriff? Well, we've already talked about the fact that deadbeat Dan might actually be in the neighboring county. If he's in the neighboring county, does that make your complaint invalid if you file it in the Superior Court across the street from you? No, you're correct, Casey. Why is that?
Because it could be where the contract was executed.
Well, I'm not sure a venue would be correct in the county where the contract is executed. But what do we have in Georgia that allows a case that's brought in the wrong county to be sent to the right county? It's the uniform transfer rules. However, the sheriff in our county, the one that's right next door across the street, what is he going to do if he has the complaint in hand, even if it's on Friday night, and he wants to serve it on deadbeat Dan? He's going to run up to the county line and stop and say, That's not my county. I'm not going to serve a lawsuit in another county. That's not my job, and I'm probably not authorized to do it anyway. So I'm going to the football game. So what can you do as a plaintiff if you can scramble around and get your act together in that 1 hour, perhaps 2, that you have in order to effectuate service rapidly and also to be able to prove that you were diligent at the end of the day in undertaking service on deadbeat Dan?
Hire a private process server, but you'd want to make sure that they are approved by the court.
Indeed, you can hire a private process server, and those come in 3 different categories. They come in the category of approved. I think there's some, not very many. I don't think there may be approved statewide for private process serving. There was mention of that in the statute. I'm not aware of actually ever knowing one. And then you also have another group, which is the professional people that do it on a regular basis, who have a standing order in numerous courts around their area of doing business. And they can show anybody, I've got an order already from this court. It's good for every case during this particular year. I think they have to pay a fee every year. So I have a standing order. I can just go do this in this court. You better make sure you can do it. They can do it in the neighboring court too. And then you can also go before a judge with a very short motion to get an appointment of a special process server, which is basically somebody who has to be over how old? 18 years of age and be a citizen of the United States. And what else do they have to not be? They have to not be a family member of one of the parties. They have to have no interest in the action. And you could get that person appointed. Maybe it's the barber next door to your law office. Maybe it's the flower shop owner. Maybe it's somebody who's actually in the business of doing private process serving. But you can get that person assigned to go serve deadbeat Dan. And the great thing about a private process server is they will actually keep a log of their efforts, tell you how many times they went by there to deadbeat Dan's house, what the status was when they went. You know, there was a car in the garage, there wasn't a car in the garage. I saw somebody in the house, I didn't see somebody in the house. And they will also use special techniques to either try to draw the defendant out so the defendant can be served with the complaint, or go to different lengths to track the person down and serve them with the complaint. If you serve actually deadbeat Dan, does he have to be served at his house?
No.
No. Where can deadbeat Dan be served?
Wherever he can be found.
Wherever he can be found, which is a good thing, because in the past, we've had to use various techniques to get a hold of people who were defendants in lawsuits. Even had one served at a strip club that they regularly attended one time, using the services of a person who was specially appointed and who had special appointments. So that worked, which is necessary because you got to get it done. So separately, one of the things you can do is have that person log, and then be prepared if you get way past like 5 days, because you're supposed to serve the complaint within 5 days, summons and complaint within 5 days. Be prepared to log and have an affidavit prepared by your process server saying this is we did this, this, and this, and this. Ended up being 10 days instead of 5 days. Now, there's several reasons why you need to get it served within 5 days. Does anybody know what that is?
Because it's the law.
It is the law. And if you serve after 5 days, then that at that point in time starts the time for the response period. But also, I don't know, drawing a blank, but there's the need for necessity to try to get it done as soon as you can. And there are there's one other ramification of the 5 days, and I can't remember exactly what it is. But there's one other point I wanted to make with respect to the summons and complaint. It is in the materials, and I think it's in the summons statute. It says the summons shall be attached to the complaint. So what does attached mean?
Maybe up for debate, but I'd say staple it to the front.
Yeah, so that's a secure way of knowing that you've attached the summons to the complaint, which is stapling on. If you have a complaint that's humongous, like this, you might be able to probably can clip it, but I think the general idea is because of due process, which we talked about earlier, which ultimately goes back to constitutional issues, we want to make sure that the summons, which is the order from the court that requires the defendant to respond, actually gets that summons, because otherwise it'll just be a complaint. They'll have no directions as to what to do with it. And once somebody serves the complaint, then what happens?
Starts the time period for the answer.
Okay, that's actually has now come to mind. What does the person who served the complaint have to do in order to show the court that the service had taken place? They have to file a return of service. So if it's the sheriff, they will have a form. That form will actually say, I, Sheriff John, approached the defendant on this day, personally handed the summons and complaint to Deadbeat Dan, and it used to be an onion skin type form that was filed with the clerk of court to prove that service had taken place. Similarly, a private process server has to file an affidavit of service saying, same thing. I found Deadbeat Dan, identified him by photograph. He identified himself as Deadbeat Dan. I handed him the complaint personally, along with the summons. And here I swear to the court that it was served. Now, it is that affidavit or that return of service that has to be filed within 5 days. Otherwise, it extends the time the defendant actually has to answer the complaint. If you get past 5 days after service, then the answer is actually due 30 days from the date that the proof of service was filed. Whereas if you file it within the 5 days, it's from the date of the service of the complaint. I've never actually taken advantage of that rule, probably because of being conservative. But if you're answering a complaint and you think you might be late, you might double check to see if the proof of service was timely filed, because it will extend the time there is to answer. Okay. We are not going to go into the various means of service other than the one, putting it in person's hands by a person properly appointed by the court to serve process, because there are many ins and outs associated with service of process. But as the plaintiff, you want to be very careful that you've done one at least that is correct and will stick, because you don't want to be, especially don't want to be your first day of trial and have the defendant come forward and say, remember that affirmative defense I raised a long, long time ago, insufficient service of process? You don't want to have that be a grounds by which the case is dismissed. Other than that, I think I need to mention that you do have to pay fees when you file a complaint. And how are fees calculated? And who is responsible for calculating the fees? So the fees are to be calculated by the person to make sure that you're paying the correct fee, calculated by the lawyer or party filing the complaint. How are fees paid? If it's electronic pleading, they're paid electronically using a credit card. Presumably, you might be able to give cash to the clerk or something if you're over there in the office. But the point is, you've got to count your parties. If the note was actually in favor of solvent Sally and solvent Sid, her husband, then you would have two plaintiffs and one defendant, and your fee would be different. And if you file electronically and you pay the wrong fee, what happens? Reject. And it's no fun, especially these days with electronic filing, to find out 4 days later that your complaint got rejected because you didn't pay the extra $45 or whatever is necessary for an additional party. So always count your defendants, always count your plaintiffs. Make sure you've calculated your fees correctly when you're filing the complaint, because it should populate, I would think it should populate that automatically, but we actually had, luckily not into the statute of limitations, we actually had a complaint rejected in the last month where the extra $10 wasn't paid, and you find out a couple of days later. We were just able to refile it, pay the correct fee. But that would be very frustrating if you'd gotten down the road and you learned that your complaint came out, got rejected. Sometimes, especially over holidays, it takes 4 or 5 days to learn about a rejection of a complaint.
Yeah, and you know, you're talking about the electronic filing. All 159 counties are not doing exactly the same. You've got at least 2 services that, and neither of which serves all the counties for electronic filing. They're different with it, how they, you know, how long it takes them to tell you a document has been accepted or not. So the time frame, and that there doesn't seem to be consistency with either of them. So the timeframes could be all over the board, and then add in the fact that you've got 2 electronic filing systems to deal with that add more, more moving parts to it.
That's right. I believe it may actually be the clerk at the county that ultimately accepts the pleading. And so that even no matter what service they're using, it still might be dependent on a human. And I will point out, side note, I've learned that a filing, for instance, in Fulton County, Georgia, of a motion, we'll get into that down the road, does not automatically go to the judge and does not automatically alert the judge. You have to actually send it to the staff attorney if you want the judge to know about the motion you filed in the court, which totally surprised me. I figured they would get the same email that we get once the judge is assigned, but apparently they don't. So there's still things that with respect to electronic service that are surprising. The other thing is if you've been using Odyssey throughout the course of a lawsuit, and then for some reason the other side, let's say, decides to use Peach Court and they haven't filled in all the information of all the attorneys that are supposed to get stuff, it goes on file, but it doesn't go anywhere. It doesn't get served. So that happened to us when we had both parties had used Odyssey all along, and then the other side decides to file an emergency motion on Peach Court, but they didn't put in our names or anything. We asked, and they said, oh, well, it's supposed to be procedurally updated over time, but sometimes it's 28 or 48 hours late or whatever, and getting an updating on the filling in of the data. So if the person that's filing doesn't do that themselves, then the motion might just go into ether, and it will be actually on file with the court, but nobody knows it is. So one final note, I'd mentioned that email that you put on the bottom of the complaint. Once you do that, you fall subject to, we're talking a lot about electronic filing, Uniform Superior Court Rule 36.16, which is a pretty long rule, but it basically says you're required to do electronic filing and you're required to put this information in. And once you do put the information in, and you put your signature on something, you are verifying the signatures as authentic, which puts a burden on the attorneys, for instance, not to file a copy of a note with a fake signature on it, at least that they know is fake. And also it triggers your agreement that you're going to receive everything in the future by that electronic service. And the email address you use has to be the one that's on file with the state bar. So if you are a student transferring over to a law firm and on the first day they say go file this lawsuit, chances are your email address is the one you used in law school. And it has not been updated to the one that's your new law firm. So make sure you have your most recent email address on file with the state bar, and make sure you use the one that's from the state bar on your pleading so that you in compliance with the rule. And I think that about uses up our time. Thank you for being here at Quillian's Kernels. Hopefully you learned something. Paralegals, remind your lawyers about these things. If you see something out of whack, tell them so. Tell them the fee is wrong. Tell them the signature is missing. Tell them the summons doesn't list the defendant. Remind them that they need to get served if they're at the end of the statute of limitations, need to document the service efforts of the process server. Otherwise, we all need to work as a team and make sure we covered each other's back. Thanks for being here. Come back next month.